Roz, thank you very much for inviting me to be on this panel. I have to say that initially I was thinking my caseload is a little bit different, but then I was thinking, you know, I have the same problem. I don't know that I think of it in terms of commercial litigation, but I know that when I look out in my civil cases generally, especially in the huge class action securities cases, it is so unusual to have women representing plaintiffs or defendants. I inherited a huge case a couple of years ago, and when I had my first conference in the case, I had several reactions. Number one, it was, this is my life, because every person that I had known in my legal career who was a partner happened to be representing one person or another in that case. And so I was thinking, you know, it's like a party. These are the people, I like these people. But the other thing is that there must have been 40 to 50 different parties being represented. There was one woman representing a defendant. And I have to tell you something, I was the new kid on the block. Everybody else had been involved in this case for years, and I was the newest person to come and have to get up to speed. And of course, I had done as much preparation as I possibly could, but I have to tell you, and I do not believe that I am biased in any way, shape, or form, because my law clerk, who was a male, sat in, and at the end of the initial arguments and presentations, we both agreed that the woman's presentation made the most sense, was the clearest, and really, really got us a step beyond where we were before we went down for that conference. Obviously, I was not surprised at that. And I was thinking, you know, if I could only let people know this, which of course I am doing tonight, it might be that people would think that the approach that women take, because of how they have to balance so many things in life, makes them cut to the chase, figure out what's important, get it down there, and move on. And I have to say that it's important to realize that the fact that women do have different approaches in many actually would be to the advantage of the litigant. So it does matter to me. It does matter as a judge to look out and see only men as the litigators. And I think even more importantly, in civil cases, it matters to the jury. And I think that this is something perhaps that some of the clients, the parties, do not take into account. When you look at the jury pool coming in for these big cases, we do not have like 30% women in the pool. We probably have 60% women in the pool. So when it all comes down to it, in many instances, there are more women than men on the jury. And if it's a very long case, juries often wander and think about many different things. And one of the things they might think one day is, why aren't there more women talking to us and explaining this case to us? Will that affect them? I certainly hope not, after the hours of instructions I give them on the law. But you never know. And I think that it's really important that we recognize that women have a way of putting things and doing things and organizing things. And please, I do not mean to suggest that men do not do this in some instances or cannot do this in some instances. But sometimes as I'm sitting up there on the bench and listening, I get the impression that there are those who are trying to impress us with how intelligent they are. And then there are those who want us to understand what the position of their client is and why they think they should win. And I have to tell you, in terms of as a jurist, it's much more helpful for me or to me to have somebody try and get across what it is that I need to know, as opposed to wanting me to go back to my chambers and say, gee, he's really smart.
So you can already tell how fabulous this panel is, and we're going to start with the questions, and our structure will be, I'm hoping the panel will jump in, otherwise, like a former law school professor, which I am, I'm going to call on you. So some people say that law is a profession, but the truth is, these days, law is a business. And some people say that the reason we're seeing all these men on all these cases is because men get business and women don't. Is that true? And
it may be a contributing cause to the disparity. I don't think it can nearly explain where we are, because certainly the ways of getting business include doing very good work, and women do very good work. I don't think that anybody is refusing to give work to women or anything like that, but it is certainly very important to have relationships with clients, and that is an area where women need to work hard.
Can I just say that, I think that, of course, if you do good work, people will know about that, but I think to really get business, you got to schmooze. And I think that women sometimes more reluctant to schmooze. I get many more phone calls from male partners at law firms wanting to meet me for lunch than women. And I would encourage women to just get out there and do it. There's nothing to lose by just picking up the phone and calling up a general counsel and asking to meet and letting us know that you'd like to do business with us. I think women have to feel more empowered, and some women do this. I'm not saying all women don't, but you got to schmooze and get out there, and don't think that you're going to get business just because people know that you're really good at what you do, because that won't cut it.
But I don't know if most of you saw the study that MCCA, along with PAR, the Project for Attorney Retention, and also the ABA Commission on Women did. And it was on the question of what happens with compensation, which is very much tied to business origination. And it's very disappointing, obviously, some of the results that are in the study. Most of the firms were larger than 250. They were also international. And they were made up of more partners with two-tier structure, equity, non-equity. And one of the things that was very clear is they said what determined whether someone got good compensation in the partnership structure. They said billable hours, origination, partner self-assessment, and then the evaluation by the practice group. The other thing that was also very telling is when they said what wasn't important, they listed things that sometimes I call it the relegation to the women. It's like washing dishes. And so they listed things like pro bono didn't matter, put that almost last, effective development of human capital, contribution to the firm's diversity efforts, effective leveraging of associates. Those didn't get a lot of credit. And so I come back to Sandy. I think we've become much better as a gender asking, but women don't ask as much as men do. I have never seen a man be reticent to ask me for business. In fact, they will strangle you to make sure you sit long enough so they can tell you they want the business and why they're so good. Women will kind of dance around it. Well, I don't want to abuse our relationship. And I said, well, the men don't care if they abuse it. Why should you? And so I can't stress enough, this is a relationship business, period, full stop. And if you don't know how to build relationships, then you're going to be at a disadvantage, because at the end of the day, this is not a charitable organization we're running.
So at the planning breakfast we had, I was honored to have many of my colleagues there. And so everything we're about to say really happened. There are no apocryphal stories in tonight's program. several women who are here tonight but who shall remain nameless reported real-life experiences not so long ago about doing all the work on a case, writing the brief, doing the research, getting all the trial books in order, and then when it came time to try the case, the woman was taken off and someone decided they wanted an older, and I must say, all the women reported balder, and presumably more experienced man who knew the judges to handle the matter. The same story when it came time to argue an appeal. What should a woman do if that happens to her, or is there nothing she can do? And what role does the client have in such a situation? So maybe I'll take the second question. Now, I've already known neither of you would ever do such a thing, but what role does the general counsel have in determining who gets to try the case?
I think the general counsel has a very significant role, and if it came to my attention that was the case in one of the cases counsel was handling for us, that a woman partner or associate was doing all this work, then at the last minute was pulled off the case. That's not a firm that I would use again. I don't care what the results are. You just don't treat people that way, and it's not right and it's not fair, and that's a fundamental value issue to me. And so it's something that I have. It hasn't come to my attention. If it did, I would not have a very good reaction to that at all. I just think it's just flat out wrong. So,
but I also realize that reality kicks in. Most of the time, we don't know what's going on in a firm. And so what I've said to people is there was a time when I used to, figuratively speaking, only make it to the living room. Now I'm going into the bedroom and checking in the medicine cabinets. Because if you don't ask very direct questions, typically the dirty laundry simply is not aired. And I've had people say to me, well, that's none of your business. Not exactly that way. But the clear intent of the message was how we run the firm. And I've even had women tell me, whoa, 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 I don't need you making trouble for me. Because when you leave, I have to stay. And so you've got to make a decision if you really believe that you want things to change, how much risk are you willing to take? If you don't take some risk and do things in a different way, that is, change the rules, such as going to a client and saying, I'd like to be first chair. The client doesn't even know there's a discussion about the first chair, maybe. And once you say it, and then the client looks all enlightened, but of course you're going to be first chair now that you've asked. But if you don't take the risk to go to the client and maybe find out that things are not going as smoothly at the firm, then you're kind of fat, dumb, and happy.
I agree completely that speaking up is an enormously important part of avoiding having that kind of mistake happen. And it's a mistake from everybody's point of view to have a less knowledgeable person presenting in court than you could have. I do think that the kinds of speeches that get made, again, in reality, need to begin earlier, and they don't need to take the form of speeches. I think that at law firms there can be very collegial and open discussions between partners and associates, men and women both, about what the planning is for the next stage of the case. I'm doing all of this work on the legal research for this brief, and I'm writing this brief. Do you think when it comes time to argue, perhaps I could argue it as well? That doesn't have to be a one-way street, and I think that there are enormously constructive discussions and thought that ensues from having had those discussions throughout the process. I think it's a rare case where anybody is doing something evil or sneaky, or that you need to go to the client to get help with your own colleagues, though it can be very useful, as we've talked about, to have a relationship with the client and communications with the client that give the client comfort that you are going to be able to confidently and competently handle a big moment in court.